Welcome to Partnerships for Profit, the podcast where we bring you inside the world of joint ventures, strategic partnerships, and powerful collaborations. Each episode, you'll dive into conversations with top entrepreneurs, visionaries, and business leaders, unlocking the secrets to building profitable relationships that drive growth and success. Whether you're looking to expand your network, find new referral partners, or scale your business, you're in the right place. Let's get started.
Welcome to Partnerships for Profit, presented by Leduc Entertainment. Today we are joined by Brian Pollock, an employment attorney and the owner and founder of FairLaw Firm. Brian, welcome to the show.
Adrian, good to see you, and thanks for having me.
Can you start off by telling us a little bit about yourself and telling us a little bit about FairLaw?
Yeah, sure. I was born and raised here in South Florida. Got my family, got my kids, and along the road have been working as an attorney for the past 25 years. The past, let's say 15 or 20 or so, was in a situation in which I just realized that I could do a lot of good, not working within a corporate hierarchy, working for myself, and in working for myself, trying to help those around me put themselves in a better position by representing employees and employers in navigating the complexities and problems that jump up in the workplace. And so, got my firm here, and we've got a great support system and staff that work with me, and we constantly try to innovate to either avoid litigation and problems, or if they come up, try to get the best result we can in the most efficient way.
Well, and can you tell me a little bit about the people that come to FairLaw? What are some of the problems they're experiencing? What are some of the pain points that you're helping them solve?
Geez, I mean, unfortunately, we get people that we can't help because they bring up issues that are interpersonal ones or just bad boss things that we can't help. And it just pains me when that happens. A lot of the issues that we do help clients with, for employers, we help businesses try to avoid problem situations, whether that be through creating or updating existing documents, onboarding, personnel manuals, to responding to government investigations.
Wow.
With let's say an administrative agency, when they come in and there's a discrimination claim or a harassment claim, even in litigation, if somebody's sued because they allegedly didn't pay all the wages that were owed or broke a contract. On the other side, we get terrible stories from people who worked for a company and they either weren't paid at all, they weren't paid what they were supposed to be, or, besides being discriminated or harassed, they brought up an issue or they made a claim for workers' compensation or something, and then they get fired. And so you take somebody who's injured and they're not at full speed down on their luck, and then they lose their job, or they're pregnant and they lose their job, and, they're not in a situation to get a new one. So, we find clients and try to help clients across the board and try to bring them to a better place, or at least bring them to equal, and utilize our resources in doing that.
So say I'm a new business owner and I'm growing my business and I'm at the point where I need to sort of hire my first employees. What are some of the legal requirements that must be addressed and met on my end before I hire?
Well, I mean, first of all, you want to make sure that you have your company registered with your state. You want to make sure that if you have any licenses that you need from any cities or counties or municipalities, you've got your business licenses. And then, if you're going to extend an offer to somebody, which is going to be the first part in working together, you want to be clear on what it is. And so even though it's not a legal requirement, my recommendation is you make that offer in writing, even if it's a text or a WhatsApp message or an email, at least something so that the two of you can refer back to it later on, so you don't have a confusion over how much you were supposed to get paid, or, was there a commission structure, or how often. The more specific you can be now, the less problems you're going to have later, because then when somebody does start working for you and they accept your offer, you want to make sure they're legally entitled to work. So you go through and verify their employment through an I-9. They give you a completed W-4 form from the IRS. So that way, when it comes time to pay them as an employee, that the appropriate taxes are taken out so you and your employee don't have problems later on. And then you want to figure out, once you get to a certain point, or depending on the type of work that they're doing, they're getting at least the minimum wage, or they're getting paid overtime, or if there's any other requirements, such as you've got workers' compensation insurance in place, so you don't run into a big problem down the road.
Well, now that was going to be my next question, was actually, when a business doesn't take these proper steps early on to ensure that everything is done by the book and everything is done correctly, what are some of the issues they can run into?
Geez, I mean, what I've learned as a lawyer is that real life is stranger than fiction.
Right.
And, the stuff that you see and hear is just like, wow, what were you thinking? Or why didn't you think of that? And, but kind of bringing it home and making it tangible. I mean, I have situations where somebody's claiming that they were working all the time for the past 5 years, never got paid a dime. And someone who's building a business now and has been building it over the past 5 to 7 years, after the rest of their other businesses and struggles and trials and tribulations, now somebody's claiming, that they're owed $100,000 or close to it from a small business owner.
Right.
And that's devastating. Or somebody's claims a little bit of overtime, but then, and you disagree about it. And the problem with these wage cases is it's not necessarily just how much you owe that employee or don't owe them. It's the prospect of attorney's fees, because you're going to have to pay your own lawyer, because you can't you're not going to represent yourself. And if it's just your business being sued, a lot of times you can't represent your own business unless you're a lawyer. So you got to pay somebody to defend you. In a lot of wage cases, especially minimum wage or overtime, if your employee wins, they're going to get their attorney paid by you as the business owner. So it becomes a really daunting setup. And then you get these disagreements. Once you're bigger and you're subject to, let's say, anti-discrimination or anti-harassment laws, they become a little bit more complex. But, the wage cases, they're really prolific. They're hard to defend because a lot of them are set up in the employee's favor. But documentation is just, it's the equalizer. And so, right. That's where I come off on this. And listen, representing employees, representing employers, I like to be more on the conservative side instead of, let's see what happens. I advise clients, to document what goes on and how you classify employees and how you're going to pay them and what you're going to have, so that if there is a problem, hey, I have no issue. Here's what I have to defend myself. Go away. And, that's the best defense is, hey, I have all the documents.
Right.
What are we doing here? And then, those cases don't go anywhere. And that's the best result for me, because listen, I make money when I represent people and the case goes on for a while, or I get paid at the end of it. But it gives me great gratitude. And when I can help somebody out and they've just won a case and the other side, the employee goes away with nothing. And, that employer is my biggest fan.
Right.
So,
right. So proper documentation is just absolutely crucial.
Absolutely. In any circumstance. I mean, if you've got an employee who's complaining about they're being discriminated against, well, you want to document it, even though it's not great for you. Because if that employee comes back and says, no, I told you, Adrian, I told Mr. Ferrara that I was being harassed many times, and you don't have any documents of when.
Right.
The employee can say that all day long. But if you wrote it down or sent an email to somebody or made a note or sent an email to yourself or just sent an email to the employee, hey, I heard your complaint, I'm looking into it.
Right.
Well, I documented the one. What are you saying? There were others that I didn't document. How come you didn't bring it up to me? And it doesn't become as believable.
Right.
So even though it's something that you don't think really helps you, again, you hit it dead on. Documentation is the key.
And can you speak a little bit about the importance of a positive, company culture? And can you talk a little bit about, how do you foster that? How do you build that into your strategy?
It's funny you bring that up, because there's some content that's going up on my website soon that it really addresses almost that exact issue. And one of the things is, and we talk about workplace bullying and a positive attitude. And here in Florida, there's no bad boss law. Your boss can yell and scream at you as long as it doesn't involve anything that's discriminatory or retaliatory or involve a protected class, especially for small employers who a lot of times don't fall into or are subject to these laws that deal with discrimination or harassment. But
Right.
putting that aside, you want employees who are happy, who want to come to work. And so to foster a healthy and productive work environment, you want to have structure. And I think communication and consistency are the backbones of a productive workplace and a happy workplace. Because if there's communication back and forth, then when there's a problem, or when someone is a problem. And if someone's a problem and you can eliminate that someone and
Right.
really build the rest of your workforce, then why not? If there's consistency of how you handle situations, then your employees have comfort in knowing that, okay, there's a problem, I'm going to bring it up and it's going to get handled, as opposed to driving into work or taking a train into work or an Uber and being just nervous about going in and what's going to happen today.
Right.
And being on edge. And then what happens as a result of that? One, employee culture is terrible. So at the
Right.
workplace, nobody wants to be there. And then it becomes, depending on what you do, it can be super dangerous. I mean, if your employees are focused on worrying what's going to happen next, as opposed to what they're supposed to do in front of or near a machine.
Right.
I mean, imagine what happens if a couple employees around see somebody seriously injured. I mean, that's terrible. The employee who's seriously injured, got people around him, doesn't deal with really what my area of law.
Right.
I'm not going to make a claim because somebody was, impacted by, scared of seeing an employee get injured. But, the other part is really teaching and having this communication and consistency. And that comes back to having, good work documents. So,
Right.
what does that come through with communication? The clearest form is in writing, and you have an employee or a personnel handbook or manual. And that sets forth all the expectations that you're going to need.
Right.
When are you supposed to be at work? When are you going to get paid? How often? How many days off do you get? When do you get off that are holidays? Who do you report a problem to? Who do you report when you're going to be late? What are your rights if you need to take leave? Is the company going to tolerate any kind of harassment or discrimination or
Right.
not? And so having good communication, having it in writing, and then being consistent in how you apply it is one of the best ways. And then there's the intangibles. I mean, in what I've seen in litigation, walking into a mediation where you've got everybody there, even if it's a wage case, the way that I see it, and I know I talk to clients, you feel like work is a family. And, you'll have families that appreciate one another. You have families that
Right.
different members are jealous of other people, or they're annoyed. You have those dynamics. And so if you can look at it like that and really try to appreciate those around you and have a level of mutual respect, it's going to go a long way.
Yeah.
In
Absolutely.
productivity and profit and, having smooth operations, having people work together as a team. It comes down to, communication consistency, and then you add the respect element to it, and, everything else will fall into play.
Absolutely. And we've talked a little bit, obviously, about the importance of documentation. I have to imagine that there is a pretty big discovery phase in what you do as an employment attorney. I mean, what is the strategy when a business comes to you or somebody comes to you and you have to go in and find out what was documented? What does that look like, that process of figuring out what was documented and what was actually on the books and on the papers?
It's a multi-step process, because initially what I find is we'll ask for documents from our clients, from businesses, and they kind of give us what they think we need.
Right.
And we review that. And then we'll have another conversation and we'll start talking about, hey, what about this? Did you did you exchange text messages? Did you have any messaging at the office? What about, like a group WhatsApp? Oh yeah, I have that stuff. Okay, well, what about, and you start digging in, and the more discussions and conversations and each layer, you start finding more information. And then ultimately, the idea is you have almost everything that that exists.
Right.
And that just comes with having more conversations and going deeper than just, hey, send me your documents.
Right.
Because, let's face it, as a business owner, it's a real royal pain to stop what you're doing and either do it yourself or have somebody at work stop what they're doing and go get a bunch of stuff that you have to download and find, or go grab paperwork and
Right.
then ship it over to send it to your lawyer, or share a Dropbox or a Drive. That's not going to help you in the course of your day moving your business. That's a pain in the butt. Nobody wants to do it.
Right.
It drags the business down because it takes somebody away from doing something they were otherwise going to do
Right.
during the day. So, it's a hard thing to do, but, for me as a lawyer, I love it when clients give me more than what I need, because then I get the full picture, and
Right.
it saves me in my office from having to bother my clients about, hey, can you give us this too? So it's an evolving process. Unfortunately, discovery as a whole is an expensive process, but it's really enlightening.
Right. And can you speak to us a little bit about the risks of employee misclassification, and what are some of the strategies that business owners can utilize to avoid those risks?
So there's a lot of risk that I find with employee misclassification, and here in South Florida, we're probably not isolated, but we see a lot of it. It's pretty rampant, and I've been on both sides of it. I've litigated it. I've taken them to trial. Cases I've won on that issue. Cases I've lost on that issue.
Right.
And the reasons why, and I get it, because it's cheaper to classify and pay somebody as an independent contractor. One, you can pay them kind of whatever you want. Number two, you're not paying taxes on it as a business owner. Number three, you don't have to pay workers' comp. Number four, you're not paying all the federal withholdings, the FICA and Social Security and Medicare. You're not doing any of that stuff.
Right.
The problem comes in when you're also not paying overtime or minimum wage, and then somebody says, hey, what about me? Or the other problem is when you pay somebody their regular wages as an employee, but then you pay their commissions as an independent contractor. And in that respect,
Right.
You're one or the other. You're either pregnant or you're not. You
Right.
can't be pregnant and not pregnant at the same time. You can't be an independent contractor and an employee at the same time.
Right.
And the risks are, one, you have the IRS come in and they do an audit. Two, an employee can file a form requesting to be reclassified, which the IRS may take up and review. But the other situations come in from a tax standpoint. Workers' compensation comes in and says, hey, these people are really employees, and they hit you for a big back bill. They audit you and then you get a big bill. The other part comes in if you get sued by someone who should have been paid as an employee because they didn't get paid wages.
Right.
They can recover overtime. They can recover minimum wage. If they're successful under federal or Florida law in not getting paid the overtime or minimum wage that they're claiming, and they win that case, the employer is responsible for the wages for 2 to 3 years under federal law. Minimum wages can go back 5 years under Florida law.
Mm.
And then unless there's a legitimate legal reason why they weren't classified and paid as an employee, that amount can double. Meanwhile, you've been paying your lawyer. And if the employee wins, you pay theirs. So, there's cases that are, hundreds, if not a couple $1,000s that cost an employer close to $100,000 just for one person. And if it happens across the board, move that comma over and you keep moving it over depending on how many people, it could be a huge costly mistake. Sometimes it's intentional, other times it's not. But those misclassification cases become a slippery slope. And so on those, for me, I'm more conservative because I look at the risk of what happens if, is it worth it to save a couple bucks here and there? But again, I can only advise. I can give my opinion. Everybody's got an opinion.
Right.
I think mine's reasoned and a legal one, but you're going to do what you want with it.
Right. Absolutely. And I guess the question is, and I find this interesting, is what happens if somebody doesn't follow that advice? I mean, do you ever find yourself in a situation where somebody just is not following what you're telling them?
All the time.
I,
if clients followed my advice or other lawyers' advice all the time, there'd be a ton more lawyers looking for jobs all the time. Because, if we advise and clients listen, then great. Then litigation goes down, problems go down. Contracts are either negotiated or renegotiated, and there's no problem.
right.
Or they're just followed, or agreements are followed, or people aren't fired, discriminated against. That's it. There's no problems. But unfortunately, it doesn't happen for one reason or another. And again, all we can do as lawyers is make a recommendation. It's ultimately the client's decision. And that's whether they're going to classify somebody, whether we're going to file a lawsuit or not, or how we're going to defend a case.
Right.
Whether we're going to settle, how much, or if, we're going to go take the case to trial. Those aren't my decisions.
Right.
I try to make I do make recommendations. I try to explain so my clients understand the reasons for them, and then it's in their hands. And I try to go ahead and pursue my clients' wishes to the extent I can, but we can only recommend. We can't force anybody to do anything, and that's where we leave it.
Can you talk a little bit about employee handbooks and some of the policies that should be included in an employee handbook to sort of protect your business?
Absolutely. And I was just working with a client who's a lawyer and has a real nice law firm and has a great business, and he wanted me to either do or redo his handbook, or personnel manual. And one of the things we talked about and revised was not just calling it an employee manual, but also just a personnel manual. That way you can encompass not only employees, but independent contractors who regularly work for the company. Again, just to have those expectations in line. But I think it's important to talk about, what's on everybody's mind. The reason why you go to work isn't just personal satisfaction. It's so you can pay your bills. So,
right.
Talk about pay. How is it going to be? Are you going to be an exempt employee who doesn't have to get paid overtime because either one, you're making too much money, or two, because of your salary and your job duties, you're entitled to get paid only a salary? Or are you going to be not exempt, meaning you're entitled to get overtime and or minimum wage, and then you're going to be hourly?
Right.
And, so you want to talk about that. You want to talk about how do we keep time for the hourly employees? And how often are we going to get paid?
Right.
How often are we going to pay our employees? So that way everybody knows. You want to have policies dealing with discrimination and harassment. You want to talk about the benefits of what kind of leave, whether paid or unpaid, what holidays, what are the hours, that you're not going to tolerate as an employer any kind of unlawful discrimination or harassment or retaliation. That if there's a problem, who do you communicate that problem to?
Right.
If they're not available, what's the next step, and what are the steps that we're going to follow? And if somebody is out of line, well, is it going to be a strict system where we're going to go through steps 1, 2, and 3 and then fire on the 4th? Or is it going to be, solely progressive like that? Or are we as the employer allowed to skip a step? And if so, does it depend on the severity of what's going on? I mean, if somebody's stealing from your business or, making personal threats and they bring a gun to work and they point it at somebody, are you going to tolerate them because you have this progressive discipline
system, right?
Or you let a step from 0 to the end and say, what, I don't think this is going to work out.
Yeah, we don't have to walk through steps 1 through. Yeah,
exactly. So all those come into play, and then so as much as you can include in there,
Right.
Again, to communicate and be clear and be consistent of what's going to be expected of your employees and also what they can expect from you.
Right.
And, the more that you can lay out as far as your time and payroll, discrimination, anti-discrimination, reporting, harassment, leave, how are you going to deal with an employee who needs to breastfeed at the office? Are they going to be provided with an area to do that?
Right.
What about service members? How are you going to deal with somebody who it needs to go to their reserve duties? All these different components can go into it, and then it can go further than that. If you've got a landscaping business, because you're going to have people driving, well, what are do you want people to be able to take those trucks home? Do you want them to wear certain protective equipment, and is that a requirement? So you want to talk about what's the work attire, and and what happens if it's broken or you have equipment. So the more you can specify, that they need to have steel-toed boots because something can fall on their feet, or you need to wear gloves so that way if you're working with a piece of equipment that can burn your hand, you're protected, or your eyes, or a mask because of
Right.
who you're around or what kind of chemicals. The more that you can show that you care and want people protected, your employees to be protected from harm, and two, from your business standpoint, you don't want to expose yourself to unnecessary risks that you can prevent by clear communication and expectations. And, the handbook or the manual is one aspect, but then talk about procedures, and the more that you can have those written out so that your employees understand what's going to happen and how to do things, and then it's consistent, it makes managing and evaluating your personnel a lot easier.
And it's interesting. I was wondering, what sort of steps can employers enact and put in place to make sure that their hiring practices are non-discriminatory, and that their hiring practices are inclusive and are promoting diversity? How can they ensure that? Bit of a loaded question, I know. I'm sorry.
It's a bit of a loaded question, and the one thing, or the word that I don't like using is ensure. My pockets aren't big enough to insure, and so we try to avoid discriminatory practices. And I think doing that is, first of all, being conscious of not just who are protected classes, right? Whether it's race, religion,
Right.
your sex, your national origin, whether you have a disability or don't, whether you're a service member. Putting all that aside, I think it's looking beyond, the color, complexion, the accent, of who's in front of you, and whether they've got their age. Put that beyond it and judge on abilities. Judge on and make your decisions based on who's going to be the best fit for this particular position that I'm hiring. And, that's one way about it. And the second way about it is, to be educated on not asking the questions that are going to get you in trouble. I mean,
Right.
If you're in an interview and, you've got someone who you may be interested in across the table, it's probably not a good idea during or after or before the interview to ask them to go have a drink or a meal with you. It's probably not a good one.
Right.
So you want to conduct yourself as though, let's say, your spouse, significant other, or parent is sitting next to you at the interview. And how would they evaluate your conduct, or your child? And if you'd act like this in front of a family member, or ask those questions in front of a family member, not a legal guide, but practically speaking, you're probably going to be okay.
Yeah.
If you're comfortable doing that in public, you're probably going to be okay. If it's something you're going to be uncomfortable asking, or going to be embarrassed about, or not feel good about afterwards, probably not a good question to ask.
Yeah. Now, you can say something. No, I speak with a lot of attorneys on the show, but you can say something not all of them can say, that you have fought for a client all the way up until the Supreme Court level. Can you talk a little bit about that process and what that was like?
Geez, that was years ago when I was working for somebody else, and the firm was hired to handle a case involving a plane crash that happened overseas. And so court systems in other countries aren't set up to award the same way as our US system. And so in that case, it involved a plane crash that happened overseas.
Wow.
And so the attempt in that case was very technical in that we were trying to get the Supreme Court to agree that we should be able to bring that case here in the US because it failed at the prior levels. Because here in the US, in the federal system, we've really only got 3 levels of courts when you come to civil courts. There's a district court, there's a circuit court of appeals, and then you've got the Supreme Court. So taking and going through those steps is not an easy one. And as you go higher up, the level of interaction you have personal with the court goes down. Your chances of success go down significantly, because if you've got about, I think it's in the 11th Circuit, it's a 5 or it's less than a 10% chance to get the district or trial court's decision overturned, and it may be less than 5.
Oh, wow.
Then when you go to the Supreme Court, it shrinks significantly. So you're talking about single percentages of single percentages.
Wow.
And their Supreme Court's obscenely selective in a good way, because otherwise they'd be inundated, because there's one Supreme Court, they've got a set amount of judges, they've got limited resources, and they want to take on and tackle the most important issues. So it does make sense. So, and as you go up this hierarchy, the challenges and demands of how you write and what you put in something go up, and how the format of that, how particular it gets, increases.
Right.
So, the technicalities increase. I think and it's taught me a lot. I mean, about how, what you want to set up early in a case. And I've learned from that, because you don't know where any case is going to end up. And if you take, you handle every case as though it's important, it can end up on appeal. Judges ultimately look at the submissions that we provide, and they respect them because they know that we're not just going to throw anything out. And so, that's how I look at my office. That's how I look at the practice and everything that we put out. And, I have the conversations all the time that this is something, every email, every letter, every motion, every response, it should all look as though we're proud of it. We could walk in front of a federal judge who's appointed for life and be proud of everything that we've done. And and I think that's important.
Can you tell us a little bit about the recognition you received from super lawyers?
Yeah, I mean, I have been a super lawyer, I think when I was younger, 2013, 2014, and then for the past 5 or so years, I've been voted a super lawyer, and have that recognition. I think you're voted by your peers, so it's a peer-to-peer recognition, which is nice that peers do that. I've been asked by colleagues to also be a chairperson for the Miami-Dade County Bar Association's employment law section, which I did for a year. And I enjoy that. So,
can you tell us maybe a story of either an individual or a business that you helped that you really saw a transformation in as a result of your help and guidance? Again, this is another one of those loaded questions.
Sure. I mean, there's a business that I represented years ago, and he was sued by an employee who was claiming that she had worked overtime. And, we worked through that issue. The next thing we did was talk about employment agreements and, work through those and work through handbooks. And so when the client came back to me, and I'm fortunate that I have clients, several years later will say, hey, remember me, you helped me. We worked through another situation where there was a claim that an employee was discriminated against. And, by using the handbook, the employee agreement, gathering witness statements, going through and winning that case, because it's, it's easy to settle a case, but winning a case is really hard to do. And so when you get a judgment by a decision by a judge in your favor for an employer, it's expensive, but it deters a lot of people because it demonstrates, one, that you haven't done anything wrong, and number two, that you're willing to stand up for your business and your principles. And so, those have been great successes, which have transferred into others. So when I have other situations where friends of mine who I've represented, it's important in their business that, they don't settle, where we did our investigation, we did the administrative process, we litigated the case, and the other side agreed, not just to drop the case, but that we would get another judgment for the employer in our favor, that we did nothing wrong. I mean,
Wow.
Those go a long way, because when when these clients get asked, hey, what about this lawsuit? Didn't you get sued? And the client says, unfortunately, I can't stop somebody from suing me. But if you look at the last document that's there, it shows that we won.
Right.
And which means we didn't do anything wrong. We've been vindicated.
Right.
I mean, that's a great success. And, the wins are great. I remember those. Unfortunately, it doesn't always happen. We lose cases too. And, we learn from them. But even in cases that we've lost, still talk to clients who say, hey, it was a jury's decision. I don't know what they were thinking. We totally had them. And, but that's the crapshoot that happens when you get to a jury.
Right.
But if you can get a judge to decide it in your favor, that's really powerful. And, those clients will never forget it. And I don't forget it.
Absolutely. Brian, this has been an awesome conversation. Thank you so much for stopping by and talking. If anybody out there listening could use your help, could use the help of FairLaw Firm, where can the people find you?
Sure. First of all, I want to just say thanks for having me on. I really appreciate it. And, letting me be long-winded as a lawyer.
So
we're here in South Florida. We handle cases all over Florida. And if it's not a Florida case, we'll try to put you in touch with somebody who can handle it for you. Our website is fairlawattorney.com. If you want to contact us, you can just type in my name, Brian, at fairlawattorney.com, or you can call us at the office, 305-230-4884, and we'll answer your call. We'll take some information. We'll get back to you. And, I think you'll find that we've got a pretty good structured way of handling people that call us and responding to them, because we pride ourselves on being responsive to people that call us, because, let's face it, that's the lifeblood of our business.
That's it. Brian, thank you so much for stopping by. And thank you everyone for listening. This has been Partnerships for Profit presented by Leduc Entertainment. Thanks again, Brian.
Thanks, Adrian. Thanks, everybody. Take care.
Thanks for joining us on this episode of Partnerships for Profit. We hope you've gained valuable insights on how to form profitable partnerships and take your business to the next level. Be sure to subscribe and leave us a review wherever you listen to podcasts so you never miss an episode. Got a partnership story to share or someone you'd like to see featured on the show? Reach out to us. Until next time, keep building those partnerships for profit.